My name is Andreas, and I'm a lawyer with Legalline and legalline.ca, and we give away free legal information online. We help about 35,000 people a day, and we answer pretty much every legal inquiry you may have in 107 languages, 24/7, 365, completely for free. For the last few months, I've been working with the lovely Sarah from Western Law School, and through our collaboration with Pro Bono Students Canada, we have been reviewing the credit, debt, and bankruptcy area of law. And that's what we're here to talk about today.
Today we'll be discussing aspects that are commonly misunderstood about debt collection. So a lot of the time when people go bankrupt, they're stressed, scared, and even embarrassed, which results in them making certain assumptions or quick judgments and choices. Today, we'll be focusing on 3 topics that this doesn't happen. First, what collectors can and can't do. Second, how and why people give up their rights without even knowing it. And third, classifications about how different types of debt are treated.
So let's jump right into it. What are the main things that people get wrong about what collectors can and can't do?
Starting off, let's clear up one major misconception. Many people assume that once debt goes to collections, the collector suddenly has unlimited power, and in reality, that's not true.
It reminds I'm thinking of some Hollywood scenes right now where debt collectors are calling you every day, showing up unannounced and making a scene. Is that sort of where you're going with this?
Exactly. In reality, collection agencies are heavily regulated under the Collection and Debt Settlement Services Act. This section focuses on separating what collectors can do versus what they cannot do. So, for example, before a collection agency can even contact a debtor, it must first send a written notice by mail identifying the creditor, the amount owed, and their proof of authority to collect. Only 6 days after this notice can they actually begin contact with the debtor.
So they can't just jump the gun on you.
No.
And start calling you all day, all night from the jump.
Exactly. They have to wait a certain period before they can actually begin contacting the debtor.
What else is going on? That's an obvious one. That's a sexy Hollywood one, but in the nitty-gritty, what else are people getting wrong?
Another myth is that collectors can call you endlessly. But the law is very clear that a collection agency cannot contact someone more than 3 times in a 7-day period.
So the law and the government is trying to prevent this sort of harassment type of situation.
Exactly. The only way that they could contact you more than that is if you previously consented to it. So
and are people consenting almost by accident or unknowingly? Is that really the crux of this issue?
They're just calling you and people are letting it happen. So if you say, stop calling me, they have to stop calling you. However, it actually is still important to note that if the creditor does start a formal complaint and there is no response for a certain period of time, this can result in the court eventually issuing a default judgment. So to avoid that, we do want to answer creditors, but of course the harassment is illegal.
So the solution is not to go AWOL.
Exactly. There's another strong misconception around third-party contact. Collectors cannot contact employers, family, friends about what you owe.
So they're not allowed to embarrass you or try to peer pressure you into getting back to them.
Exactly. The only person that they can contact about your debt is you. So that's another misconception. And if they do start doing that, that is something to take note of and potentially a complaint. The last myth about what collectors can or can't do is that they can say that a lawsuit started when it hasn't. Even if a creditor could sue, presenting litigation as if they've already started it
to scare you
is not allowed. Often, creditors will do this because in reality, actually starting the legal action is very expensive.
Time-consuming.
Exactly, resources. So they'll use it as a threat to get payment. But they cannot do this. So any false or misleading statements, including exaggerating any legal consequences that they've started the process, is explicitly prohibited.
I'm noticing a trend. These myths all seem to be about perhaps a creditor or a collector taking methods to intimidate or scare or, get someone in a financially difficult position to acquiesce to whatever they're saying when maybe the situation isn't really what it seems to be.
That's exactly the crux of the issue. And of course, by knowing these things, that's the best way to avoid it.
And protect yourself or not shoot yourself in the foot, so to speak. Another issue that we get a lot of questions about is How are people giving up their rights unknowingly?
One way is that they provide unnecessary personal information. So a lot of the times, creditors will ask for all this personal information, but in reality, you actually don't have to give debt collectors your bank account or your credit card details over the phone.
So financial details are private.
Exactly. If they ask for it, you can say no, because if you give it to them, this often leads to unauthorized payments, so them taking money out of your account.
Direct withdrawals and these sort of things.
Exactly. Another way that people give up their rights is communicating verbally without keeping any records. So this would be relying solely on phone calls without any documentation.
So we want to keep a paper trail.
Exactly. Without a paper trail, it makes it very difficult to prove things such as creditor harassment or any agreed upon alternatives to the debt arrangement. So if the creditor and debtor agree that there's going to be a different way for payment and there's no documentation of this, it's very easy for the creditor to go back on this agreement.
Or maybe they've agreed on a different payment schedule or payment timeline and then later decide they want a lump sum payment up front. So you would want to ensure that those sort of agreements are in writing so that you can rely or call back on them later.
Exactly. Therefore, it is always vital to keep records of all communication and request any sort of agreement in writing. Another way that people give up their rights is dealing with unregulated debt advisors. So a lot of the time, there will be unregulated debt and advisory firms that try to get business. However, if they're not a regulated licensed insolvency trustee, this can be very risky. These companies might charge high upfront fees for services that they cannot legally provide, and then this results in further debt and no protection.
And those high upfront fees may even be illegal or would have been illegal if they were in fact regulated.
Exactly. So we want to avoid using any of these unlicensed individuals or firms because this could leave you in more debt.
Sounds like a slippery slope.
Yeah, so we want to stick to the licensed insolvency trustees. The last way that people give up their rights is not using their rights surrounding a stay of proceedings. So under Section 69.3 of the Canadian Bankruptcy and Insolvency Act, there is something called a stay of proceedings. And this is once a person files for bankruptcy or a consumer proposal, an automatic stay comes into effect.
And a stay means a stop.
Exactly.
Or a pause.
It's a freeze, exactly. So this freezes all collection activity, including calls, lawsuits, etc. But many people don't realize this, and they continue paying and answering all their creditors' calls simply because they didn't realize.
What you're saying is if someone files for bankruptcy, the creditors have to take a step back, go on a smoke break, and leave them alone.
Exactly.
For the time being, at least, until something gets sorted out.
You beat me to it. Exactly. So we just want to make sure that we're not thinking that we're in the stay when we're not actually in the stay. So it's important to know the length of the stay and when the stay
comes into effect.
Exactly.
We seem to be getting a lot of questions about secured versus unsecured debt. What's the difference between these two types of debt and how are they handled from a collection standpoint? Are they different? Are they the same?
Another major source of confusion is the idea that all debt is collected in the same way. But in reality, the legal process for the collection of debt actually completely depends on the type of debt being collected. This section explains the difference between having secured and unsecured debt and why that distinction actually matters in terms of the debt collection process.
Let's start off with some definitions. What is secured debt? What is unsecured debt?
Secured debt is tied to collateral, meaning that this is property that the lender can rely on. Whereas unsecured debt, just like this.
So for example, you may have debt on a vehicle and the debt has been secured to that vehicle as collateral.
Exactly. Whereas unsecured debt, just like the title, doesn't have collateral.
A little bit loosey-goosey in the air.
Exactly.
General debt.
Exactly. So that would not be tied to any sort of asset or item. The truth is that only secured creditors have a built-in right to specific property. Unsecured creditors must go through court first. So first we'll talk about secured debt. As we said, it's tied to collateral. And the law on this comes from the Ontario Personal Property Security Act in Section 62(1), which states that when a debtor defaults, the creditor has the right to take possession of the collateral by any method permitted by law. So, just to explain this more clearly, some common examples of this would be mortgages and car loans, as we mentioned before. And this means that a secured creditor can seize and sell the collateral if you default, but may still pursue you for a shortfall if the collateral doesn't necessarily cover the amount owed.
Right. They're not limited to the collateral. It's just they have the first right to that collateral.
Exactly.
Versus unsecured creditors
Unsecured creditors don't have a right to any piece of property.
in particular.
Yes. So this is because the creditor's protection is the asset and not any income or money. Although they can later also go through the court process and get money if the collateral doesn't cover it. So conversely, now let's talk about unsecured debt. So as we said, unsecured debt has no collateral, and it's governed by Ontario's rules of civil procedure, specifically Rule 60, which defines a creditor as someone who is entitled to enforce a court order in order to receive payment or recovery of money.
So an example of this might be if your friend loans you $5,000 and that's it. That's the whole arrangement. There's no details. There's no collateral.
Exactly. This means that garnishment and seizure can only exist after the creditor has sued. So people actually often think that a creditor can just take away your wages or just automatically take money out of your bank account.
Repo your stuff.
In reality, they actually have to sue the debtor and obtain a court judgment. So both of those two things. And only after they do those things can the garnishment actually occur. So there's no automatic taking money. There's no automatic
Taking stuff.
There's
a longer process.
Exactly. Understanding these rules doesn't make debt disappear, but it does change the balance of power. It allows people to make decisions based on accurate information rather than things that they believe or these myths that we've been discussing. If a situation does feel overwhelming, there are many options and professionals who can help.
If you or someone you care about is experiencing financial hardship, contact 4 Pillars at 4pillars.ca for compassionate help. Thank you for joining me, Sarah. This was a blast.
Thank you for having me.